Hello everyone, this is your host Syed Amir Hussain. Welcome to Courts Today by Livelaw, your one-step destination to all legal developments in the country. The Supreme Court today refused to entertain a writ petition alleging booth capturing and rigging of elections in the constituency of Munger in Bihar by members of the JDU. They had sought directions for repolling and recounting of the votes in certain booths. The petition alleged booth capturing and rigging of the elections in Munger constituency allegedly by the members of the ruling party JDU along with the aid of government officials. It was alleged that several representations were made to the authorities including the Election Commission of India as well as District Election Officer, but to no avail. The matter was today heard by the bench of Justices Satish Chandra Sharma and Prasanna B. Varale. It dismissed the petition and stressed that it was crucial for the petitioners to first approach the High Court. Due to the severe heat wave conditions prevailing in the North India, particularly Delhi, there is an extraordinary and excessive surge of water demand in the capital. It is facing acute shortage despite the government taking possible administrative measures to ensure optimization, rationing and targeted supply. As such, there is a need for additional water supply. The Delhi government has thus approached the Supreme Court seeking directions to the state of Haryana for immediate release of water to the crisis-hit national capital. It is further stated that Delhi, a lower riparian union territory, is seeking additional water supply only in view of the emergent situation created by the dry, arid summer this year. In the petition, it has been stated that the state of Himachal Pradesh has agreed to share its surplus water with Delhi, but it does not share a physical boundary with the union territory, and thus the water is required to be routed through existing water river systems in the state of Haryana to be eventually released in Delhi. In this backdrop, the plea adds that the Delhi government has made a request to the state of Haryana, but the latter has not acceded to it yet. Accordingly, through this plea, directions are sought so that the state of Haryana offers its cooperation and releases water to Delhi, including the surplus water agreed to be released by Himachal Pradesh. Also, you must know that amidst the water woes, Delhi Water Minister Atishi Marlena issued an order last week stating that wastage of water by anyone shall attract a fine of 2,000 rupees. The Supreme Court bench of Justices Sanjay Karol and Arvind Kumar today refused to entertain the petition filed by Abhishek Dangi challenging his rejection of nomination from Jehanabad constituency in Bihar as an independent candidate in the Lok Sabha elections 2024. He had filed an SLP before the top court against the order of the Patna High Court, which dismissed his writ petition. Before the High Court, Dangi argued that his nomination was rejected on hyper-technical grounds on 15th of May by the returning officer. As per the polling date for his constituency, which was 1st June, he sought a direction against the ECI to accept his nomination. ECI, on the other hand, had challenged the petition's maintainability in view of Article 329. This article places a bar to interference by courts in electoral matters. So, the ECI had contended that electoral process once started could not be interfered with at any intermediary stage by courts. Today, the top court asked the petitioner's counsel to approach the High Court Division Bench by way of a letter patents appeal or file an election petition. Accordingly, the counsel withdrew the petition. You are aware of the recent incident of alleged assault on Aam Aadmi Party Rajya Sabha MP Swati Maliwal by the close aide of CM Kejriwal, Bibhav Kumar. Maliwal alleged that Bibhav Kumar assaulted her when she went to meet Kejriwal at his residence on 13th May. An FIR was filed after this and Kumar was arrested on 18th this month. Today, the Delhi High Court bench comprising Acting Chief Justice Manmohan and Justice Manmeet Preetham Singh Arora heard a public interest litigation filed by a lawyer to stop the media from disclosing the name of Aam Aadmi Party Rajya Sabha MP Swati Maliwal while reporting the assault case, along with contents of the FIR. The petitioner was aggrieved by the action of media houses as well as social media platforms Meta, X and WhatsApp for circulating the copy of the FIR publicly and disclosing the identity of the victim. According to him, such disclosure certainly lowers down the dignity of a woman. The PIL also sought direction on the union government and Delhi government as well as the media and social media platforms to not disclose the name, address, other identities of the victim in sensitive matters such as rape or molestation, etc. But the court refused to entertain the PIL, remarking that there was a political color behind the petition. The court also said that if Maliwal, the victim, is going to the media channels and talking about the case, what locus does the petitioner have to file the PIL? After the PIL was withdrawn. Also, let me tell you today, Delhi High Court has reserved order on maintainability of the plea filed by Bibhav Kumar challenging his arrest in the alleged Swati Maliwal assault case. Senior advocate Sanjay Jain, appearing for the Delhi police, raised preliminary objections to the petition. He said the petition was not maintainable as Kumar in his petition did not disclose that he had filed an application before the trial court on the issue of non-compliance of section 41A of CRPC, which was rejected. He further said that no interim relief was sought in the petition and thus there was no urgency for the matter to be heard on the last day before the court breaks for summer vacation. On the other hand, senior advocate N. Hariharan, appearing for Kumar, said that the main prayer in this plea is to declare the arrest illegal and the matter involves issue of personal liberty which should not be taken lightly. He said that there was no necessity of effecting Kumar's arrest and that even the grounds of arrest were not provided to him. After hearing the parties, Justice Swarnkanta Sharma reserved the judgment in the matter. Stay tuned. Various media channels have reported that Prime Minister Narendra Modi is holding a 45-hour-long Dhyaan or meditation at the Vivekananda Rock in Kanyakumari starting on the evening of 30th May. As part of the PM's visit, security has been tightened at the site and entry of tourists has been restricted during these days. Tamil Nadu Congress Committee has now approached the Madras High Court seeking directions to the Election Commission of India to take necessary steps to prevent alleged misuse of position by the Prime Minister during his meditation. The petition says that while no one can object to the PM's visit to Vivekananda Rock, his visit during the silent period on the final polling day of the 7th phase of the Lok Sabha elections 2024 is an attempt to whip up Hindu sentiments and is aimed at canvassing votes by misusing his official position. It is alleged that PM Modi, through his meditation, was indirectly canvassing voters, although any canvassing has to be stopped from the evening of 30th May 2024 and no political party, including the Prime Minister, should be allowed to canvass or campaign in any form. The Congress committee alleges that broadcasting this meditation through the official media would amount to canvassing and violating the Code of Conduct, which is an election offence under the Representation of People's Act. It is further submitted that if the Election Commission does not put an end to this program, it would put the opposition parties in a position of disadvantage as they cannot canvass during the cooling off period. The Madras High Court is on vacation and is expected to reopen on Monday. Do tell us about your views on the same in the comment section below. A special MCOCA court in Mumbai has sentenced gangster Rajendra Sadashiv Nikalje, also known as Chhota Rajan, to life imprisonment for the 2001 murder of hotelier Jaya Shetty. It was the prosecution's case that victim Jaya Shetty, owner of the Golden Crown Hotel in South Mumbai, faced extortion threats from Rajan's gang. Shetty had police protection, which was withdrawn 2 months before his murder. Shetty was shot dead on May 4, 2001 outside his office by 2 alleged gang members after he purportedly refused to pay the demand amount of 50,000 rupees. 3 other accused in this case have been previously convicted. Special Judge A.M. Patil under the Maharashtra Control of Organised Crime Act or MCOCA passed the judgment convicting Rajan. He was held guilty of various offences including murder, criminal conspiracy and other offences under MCOCA. During the hearing, Rajan appeared via video conferencing from Tihar jail. He has been sentenced to 4 life imprisonments. All 4 life sentences will run concurrently and the court also imposed a total fine of 16 lakhs on him. Rajan is already serving time for the 2011 murder of a journalist. He was arrested in Bali in October 2015 and deported to India and faces charges in 71 cases in Maharashtra. The Karnataka High Court today observed that the special court order granting bail to Janata Dal's secular leader H.D. Revanna, accused of kidnapping a woman, appears to be defective. H.D. Revanna is the father of Prajwal Revanna, who has been under scrutiny with allegations of rape, sexual harassment and sexual assault of several women and the shooting of over 2,900 obscene videos with multiple women without their consent and publishing it. His father was arrested for the kidnapping of a woman but later released on bail by the special court. A single-judge bench of Justice Krishna S. Dikshit, while hearing the petition filed by the Special Investigation Team seeking cancellation of his bail, orally said that there seems to be error apparent on the face of the record. The court has thus issued notice to Revanna. The court has also issued notice to the state government on the petition filed by Revanna seeking quashing of the case registered against him. Both matters have been posted to be heard on 3rd of June. The Allahabad High Court today concluded the hearing and reserved its verdict on an application filed by Shahi Eidgah Masjid challenging the maintainability of 18 suits filed concerning Mathura Shri Krishna Janmabhoomi Shahi Eidgah Masjid dispute. All 18 suits contain a common prayer seeking the removal of the Shahi Eidgah Mosque from the 13.37-acre complex it shares with the Katra Keshav Dev Temple in Mathura. Additional prayers include seeking possession of the Shahi Eidgah premises and demolition of the present structure. A bench of Justice Mayank Kumar Jain reserved the verdict after hearing the arguments of the Masjid Committee challenging the maintainability of Janmabhoomi suits and the arguments raised by the Hindu plaintiffs, including the DT. The court started hearing the Masjid Committee's objections in February this year. Stay tuned for the verdict. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Livelaw. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just ₹89 per month. Thank you for watching.